Attorney Susan Lawson and Scott Simmons from the Rossen Law Firm. We're here to share an amazing result that we had yesterday. Our client came to us facing a very serious charge of aggravated battery with a deadly weapon. He was facing up to 15 years in prison, and on the bottom of the guidelines, he scored mandatory prison. Now, our client, we truly believe was innocent, and we fought really, really hard. He has a wonderful family. He has a young daughter who is now 5 years old. He was playing football, was playing for FAU, and is about to actually graduate in the spring for FAU. But the incident happened 3 years ago, and his life has essentially been on hold for the past 3 years.
We took the case all the way up to trial. We tried to negotiate with the prosecutor beforehand. Unfortunately, we couldn't reach a resolution that both sides found fair, so we set the case for trial. We went through the process. Susan picked the jury, process called voir dire. We had the jury picked. I did opening statements. Susan cross-examined the victim, and then I cross-examined the officer. After that, I did the judgment of acquittal, which that is a motion that you file in trial, usually orally, where you're telling the judge that there was not enough facts that the state met their burden at a lower level than needed to go to the jury. So for the first one, he reserved ruling, meaning he didn't grant it, he didn't deny it. We then argued the second judgment of acquittal, and that judgment of acquittal was granted, meaning the judge found there was not enough evidence that this case should go to a jury, that the state didn't meet their burden, that our client intended to commit this crime, or that he used a deadly weapon. He dismissed the second-degree felony for both counts, and our client got to walk out of the courtroom a free man. He got to go and get his ankle monitor taken off that day, and his family got to celebrate having his life go back to normal and have him achieve his best future.
Yes, and it was an amazing result. It's very rare that judges grant judgment of acquittals. And just about a little bit about the case, we truly believe this was a situation where it was a true accident. And again, like Scott says, our client had no intent to cause any harm. And through our hard work and our preparation and our expertise in court, we were able to prevail.